Okay. Sorry, just doing a sound test. Okay,
Hello, how are you?
I'm good, thanks. So we're about. Can you see me?
I can.
All right, let's get some vision, hopefully. Great, thank you, Kay. Can't hear me? Yeah. All right, thank you. Thanks everyone for coming early. We're just about 5 minutes away, so we'll just wait till 5 if that's all right. Thanks. They're recording.
It's recording.
Okay, with 5.
1 minute.
Okay. You okay? Not you, Angus. You're right, Jess. Do we want to, I don't see the screen. No, if they want to sit over the middle. Yeah. We have Dr. Valentine on the screen. Can you see the screen? Can I ask? Yeah, okay. Well, if it suits everyone, we might get underway. First, could I start by saying welcome? It's very pleasing to see such a wonderful response. We've got about 100 registrants in person and almost 200 online. So I'm particularly grateful for that. Today, we're joined by Roberta Devereux, representing the Director of Public Prosecutions Commonwealth, Todd Fuller, KC, Director of Public Prosecutions Queensland, Joseph Briggs, Public Defender, Queensland, Angus Edwards, KC, representing the Bar, and Patrick Quinn, representing the Queensland Law Society. And we're also joined today online by Dr. Kay Valentine, who is the Chief Forensic Scientist at the Victoria Police Forensic Services Department. Dr. Valentine, I hope you can hear me.
I can. Thank you, Justice
All right,
Burns.
thank you. Thank you for coming. As you would have seen in the information that was sent out ahead of this seminar, it's really in two parts. One is the first part's to give something of an update or refresher on the expert evidence practice direction that was released last year. And the other part, or the balance of the seminar, will be devoted to the new bail pilot under the practice direction that was issued by the Chief Justice on the 19th of November. If we could go to the first part, right? So you will all recall the expert evidence practice direction applying to criminal proceedings in the Supreme Court that was published last year. It applies to any criminal proceeding commenced by indictment in this court from 15 July last year. And so it is starting to kick in. We are starting to see cases emerging to which the practice direction applies. Some of you will be familiar with some of those cases, but we'll soon reach the point where the reach of the practice direction covers each case that's prosecuted in this court. What I wanted to speak to you about today and to discuss briefly is the amendment to that practice direction that was made on the 10th of September 2025, and that is to deal with the use of generative artificial intelligence by experts. If we go to the next slide, please. So you would have seen from the previous slide at least, and I know that a copy of both this practice direction as amended and the bail pilot practice direction was emailed to each of you. But the relevant part of the expert evidence practice direction that was amended in September is a new paragraph 16L. I commit it to you to read in the context of the overall requirements under that practice direction. But essentially what it requires is for experts, where they have used generative artificial intelligence in the formulation or expression of an opinion set out in their report, they need to identify a number of things. One is the program that was used. One is the prompts or input, what was fed in at the front end of the program. Then the product or output after that process of generative artificial intelligence. That all needs to be recorded. That is what goes in and what comes out in the program used, and then disclosed to the parties. Where a code of practice exists, in relation to the use of artificial intelligence by the expert, and this will vary from expert to expert, that must be specified, and the expert has to identify how that code of practice was adhered to. And lastly, and most importantly, the expert's required to disclose anything that might affect the accuracy or reliability of the opinions expressed. So what I'm talking about there are the known limitations of the use of AI. That's just really giving you an overview of what the new requirements are. If I could turn to Dr. Valentine now. Doctor, as Chief Forensic Scientist, you have a range of responsibilities, it's fair to say, but at its core is ensuring that forensic processes used in police investigations are robust, reliable and transparent. Would that be accurate?
That is true.
I feel like I'm examining the witness here, so I'll get out of that mode. And it has to be said that you're somewhat of or indeed quite a trailblazer in this area, because our practice direction, just for the information of the people watching and listening, was based on the Victorian practice note that was published in 2014. And you were in fact a member of the Forensic Evidence Working Group that helped to formulate that practice note. And you've been a member of that group ever since.
I have.
Yeah. And I was going to ask you, given that Victoria's had effectively a similar regime, at least, it's not identical, but similar to that that's now in Queensland, by your observation, has that helped, do you think, the quality of evidence that's being advanced before the courts?
To directly answer the question, I would say yes, but it's been a game of two halves for us. So when it was first introduced in 2014, our practice note was designed to be triggered. So we would issue a forensic report in every instance, and then if directed by the court, and prosecution, defence, the court could direct us, we didn't mind who, then we would issue a expert report compliant with, apologies, I've got a fire alarm going and I may need to evacuate, but it should be fine. So it was designed to be triggered. And in the first 6 years our practice note was in operation, it was only triggered on us about 5 times. And we issue about 40,000 reports a year.
Right.
So we were a little bit confused as to why we weren't being asked for all the information that the court had very clearly signalled that should be considered with expert evidence. So in 2019, we decided that we would no longer wait for a trigger, that every report we issue would be compliant. So every opinion or statement containing opinions is now an expert report. We can't tailor it to the issues because we're not notified of them ahead of time. So we give a generic expert report that outlines all of the limitations. And since we introduced that practice, we've actually seen a very large decrease in court appearances because we're answering most of the questions up front.
All right. There's mechanism under your practice note to further refine the expert issue.
There is.
The defence can request, for example, a further report.
They absolutely can, but it's not happening to us. We tend to find that we get those questions at trial only. We're not notified ahead of time.
Right.
We would love to, because that would enable us to do the proper research and to carefully consider our opinions, but we understand that it doesn't have to happen that way. So we just address them at trial as we can.
So there's a similar provision in the Queensland Practice Direction. So it's worth highlighting that, in fact, one of the main thrusts of that practice direction is to help not just set standards for the expression of opinions and the evidence that's placed before juries, but also narrowing the issues that have to be decided by juries.
Yep.
So the step is a report's prepared, it meets the minimum standards set out in the practice direction, but yet there's a further step that can be taken by the defence to effectively say to the prosecution, well, that's the expert report on this topic, but we're interested in this particular issue, and then a report's commissioned and confined to that issue. All right. I know you've seen the amendments that I've just mentioned to the Queensland Practice Direction. We all know, of course, that just as a general proposition that artificial intelligence is rapidly evolving, at least in terms of its use. It's very difficult to do anything online without using artificial intelligence in one way or another. Sometimes we're aware of that, sometimes we're not. What about in the field of forensic science?
We are leaning very heavily into AI, but we're doing so carefully. Largely because I'm sure it's the same in Queensland, down here in Victoria, our workload is exceeding our resource capability. So we just can't keep up with demand. But also, AI offers us the potential to give more value to the courts. So where we can't currently provide opinions, because integrating the data is just, there's too much for a human brain to do, we're looking at using machine brains to do it for us. So things like time of death. Right now, a pathologist cannot tell that to you with any certainty. It is possible that with AI, we could get it down to 1 or 2 hours. Fingerprints, we could speed up our processing. DNA, we could speed it up. Certainly for drug analysis, instead of it taking weeks and weeks and weeks to identify methamphetamine, we can use AI to do it in about 30 seconds. And the other big area that we are using it for is deepfakes. So right now, deepfakes are being created with AI, and the best way to determine if something is a deepfake or not is to use AI. So we really have to start using AI wherever we can. At the moment, as far as I am aware, no one in Australia is using it for the ultimate expert opinion in forensic science. They'll be using it in the preliminary steps and it will be feeding into that expert opinion, but it's still a human giving you their specialised knowledge at the end of the day. But we will probably see a shift in the coming years to where, certainly for investigations, it's an AI giving the opinion and then a human just checking at the back end.
All right, so the Queensland amendments, the philosophy of those is fairly clear. It's to require a recording of the program that's used, the inputs and then the outputs, and an expression of opinion about known limitations. Does that cover the field for the moment at least?
For the moment, it absolutely does. I really welcome it. You've gone further than we have in Victoria with requesting the inputs and the prompts and the outputs and the limitations. We don't have that in our practice note yet. We might choose to copy you. It sends a really clear signal to the expert that disclosure and transparency is needed, and that's extremely important here. And certainly in forensic science, we will do what we do for all techniques. We will validate, we will run known cases and known stimuli through it. We will know how often it is wrong, and we should be telling you that. If that's not included when someone is using AI, then the question probably should be asked, do you know how often this hallucinates or gets the wrong answer? And how do you check it?
All right. So just before I turn to whether there's any questions from the panel, I'll just ask this. The practice note in Victoria, indeed the practice direction in Queensland, adds a layer of not regulation, but requirements or standards to work that's produced by the forensic science community. How has that been received?
We adore it. It sends us a very, very clear signal what the courts need from us. We want to provide the best possible evidence to you. We don't know the context of the case. We don't know the other evidence. All we know is our evidence. So we don't know which of our limitations or assumptions or qualifications are absolutely vital for decision making on our piece of evidence. So for us, it is a way of trying to signal to the parties in the court, please think about this because it's important. And we want to be asked questions. We want you to understand our evidence, and we know that we're sometimes a little bit complex in the way we phrase things. So the practice note gives us the chance to explain our evidence properly. So we welcome the regulation that comes with it, and we'd love any further regulation, to be honest, because it tells us how we can serve the court the best way we can.
Oh, thank you so much. I'll just ask our members of the panel whether there's any questions while we have you. Angus Edwards.
So, is this on? Yeah. I heard on the ABC today that the word of the year in the Macquarie Dictionary was AI slop, beating out even 6-7. And I wondered how you as forensic scientists would be able to know what the limitations were of AI.
So we will do very, very extensive testing, ground truth known testing. So say before we implement an AI that can compare fingerprints, we will put 100,000 pairs of fingerprints through it and check it gets the right answer. We do that with our humans currently, but it takes us a very long time to get them to do 100,000. Whereas with an AI, we can do it in the space of a week. We will not implement without doing that work. We are accredited to international standards, and it is mandated that we do that. If we don't, we lose our accreditation ability, and therefore we can't give evidence. So we have our own codes of practice and standards that we must comply with, and we will ensure we do that before we turn anything on for courts.
Thank you. Any other questions? None from the audience?
She validate 30 seconds to get methamphetamine. Is it accurate? Is it just saying it's methamphetamine? You do the full test and say it was 100% methamphetamine.
Yeah, so question from the audience, Dr. Ballantyne, I don't know whether you heard that.
I think I heard enough. It has been validated. It depends a little bit on your methamphetamine. Different states have different methamphetamine. It is about 98% accurate in 30 seconds. So is that sufficiently accurate for court purposes? That may depend on the context of the case, on the amount, all of those things. It's certainly being used in New Zealand and one state in Australia. But when it goes to contest, the full laboratory analysis gets it done, but it is serviced up until the mention. It can be done, so you've got an immediate answer.
All right, thank you. Is there any other questions? Dr. Ballantyne, thank you so much for being so with your time. I'm very relieved all the tech worked. Unless you've got a particular interest in bail applications, I'll bid you good day. Thank you.
Thank you. Thanks very much, everyone. Bye.
So the second part of the seminar, moving right along, as they say, concerns the bail pilot. Before highlighting some of its features, can I just give you some background here? As you know, our civil applications jurisdiction sits 2 judges every sitting day of the year to sit in applications. But over time, that list has been swamped by a significant increase in bail applications and also applications under the Dangerous Prisoners Sexual Offenders Act, to the extent where we now regularly have one judge fully occupied Monday hearing at least 2 applications for dangerous prisoners, another one on Tuesday, and then the 2 judges need to manage the bail applications as they come throughout the week. The initiative, which we'll speak about a little bit more, will create a separate list for bail applications and dangerous prisoner applications. They'll move them completely out of the applications list. That will free up the civil applications list, and also, we hope, enhance considerably the timely and efficient disposition of bail applications. This bail pilot's more than just moving some cases from one list to another. It's because we are doing that, we're also taking some steps, significant measures actually, to build in case management and enhance resolution of these applications, ideally before they get to a substantive hearing phase. But before we talk about the structure of the pilot and its key features, We thought we would explain a bit more about the problem the court's currently facing, at least in terms of bail applications. And to that end, if I could just hand over to Todd Fuller, who has all the statistics from his office.
Thank you. Now, I just want to take you through some of the stats that we have overall and identify some of the issues that have occurred over the last couple of years. You'll see that to the side that there were 3,691 bail hearings that proceeded between July of 22 and September of 25. You'll see that there were 726 adjournments that occurred with respect to those applications. And so those were applications that were brought but didn't then proceed for various reasons. And the defence representatives would be aware of that you find a client who may not be meritorious at that time, and there was a risk in running the matter at that stage, and then you would deny them an opportunity later on. The second one is, if you look at the line graph to the side, the increase in self-represented litigants in the bail space. That would be unsurprising to you given the changes in legislation that has occurred, particularly in the domestic violence space in matters where bail was refused in the lower court. That of itself causes a significant problem for the court and for my office in responding to those applications. And you'll note there's a couple of spikes there. Usually it's in December, and I'll show you the chart at the end about how bail has risen over time. But we actually have a name for that in our office. In December, we call that jingle bails. That's because there's like 4 times as many applications brought over that time, and we have to bring staff from southeast Queensland to be able to try to meet the need for the court. And the court sits an extra, there'll be 3 judges, I think, sitting at Christmas this year. More importantly, if you go down to the results, all right, so the granted versus refused. Now, you'll see in the middle table, you'll see where we've opposed. 1,310 were granted out of an 801 were refused. And so that's 2,111. But of those matters which were granted, we had opposed, a lot of those, there's a lot of negotiation in the last 24 hours after the application is made and actually at the door of the court, in finding addresses, in finding work, in finding things that make it amenable to the court to grant bail. And so there's a whole lot of matters there that by management may drop out of that list. So we're looking at the adjournments, we're looking at the matters where they're self-represented, and we're looking at the matters that could be unopposed because of the timely provision of material and my staff being put in a position to make sensible decisions around it. If we could go to the next page, thank you. So this is to give you an idea of the financial year of July 24 to June of 25. And so you'll see the breakdown, and you'll see that, again, the opposed up in the corner, 423 granted 423 and refused 302. So there's a closer figure than across the period of time. But again, that may be contributed to because of the change in demographic with the self-represented applicants coming through. Again, we have a significant number of self-represented applicants, and you'll see how they're spanned across that time, and a significant number of adjournments that again occurred. If I go to the next page, it shows the average number of hearings. This has had an impact on the judges, it's had an impact on the commercial list, and it's obviously had an impact on the resources within my office. And you'll see that the average is at 4, but the highest monthly average was nearly 9 a day. And we won't talk about 26, that was Christmas Eve. And if we go to the last one, which actually shows the number of bail hearings across that period of time, you'll see the spikes, no surprise, they're in December of every year, but you'll see the gradual incline of that average across the years. And so that has a resourcing implication for ourselves, for the defence, and of course, in the space of the self-represented litigants, has a significant impact upon the court and the requirements on us. So something had to change with respect to that. We've had a system where 2 days' notice was required for as long as the system has been in place. We've had an increase in the complexity of the types of matters and the types of clients who are coming before the court applying for bail, and creates difficulties on both sides of the bar table and indeed for the bench in assessing risk, in assessing conditions, and crafting bail orders that can be properly imposed. Thanks, Judge.
Thank you, Todd. No, can we just go back? Thanks. So, go forward. I just want to start with, I know you all have the practice directions, so I'm not going to read it to you, but there's an important section at the start of the practice direction about the philosophy of what the court's trying to do here. And that is, and the key component of it is that once an application's been accepted for filing, it will not be allocated any court time for a substantive hearing until it has been first reviewed by a judge. So it's a case management step. It is triaged at that point. The purpose of that initial review hearing, they will be short, no longer than 10 minutes. But that will be to ensure that all of the evidence necessary to determine the application is assembled. There'll be some time taken up refining the issue for hearing. For example, what is the risk? What is the argument about? Where are the parties apart? And then directions will be made if necessary to help facilitate the hearing. The other important part of that particular section of the practice direction is that the court does expect that practitioners will act responsibly before engaging the processes of the court. So to give you an example, where an application for bail is made in the magistrate's court but is refused, we see this time and time again. The next step that's done is material is assembled, grounds are built to support a grant of bail, and an application is filed almost automatically in the Supreme Court, when a second application to the magistrate's court could have been brought under a change of circumstances basis. So we ask practitioners to think before they file in the Supreme Court as to whether or not a second application should be made in the magistrate's court. The structure, I should point out that this is a pilot, so we're going to keep it under close review. It's a pilot for 6 months. No doubt over that time there are things we can do to improve what we're attempting, but it should be borne in mind that it is a pilot and that it will run only in Brisbane. It will apply to all types of applications under the Bail Act, so not just applications for bail, but applications for variation, revocation, and also what are in effect appeals from refusals in the magistrate's court, or appeals from grants in the magistrate's court, which is part of the jurisdiction conferred by the legislation. A separate bail list will be created. You would know that we already have a separate list for dangerous prisoners. A bail list manager, that role has been created in the registry, so there'll be a dedicated person handling these applications. There will be a bail list judge who will sit over the top of the pilot to have oversight. That is me for the first 6 months. And then, as you know, a judge will be allocated each week to hear only dangerous prisoner applications and bail applications. Although the practice direction commenced on the 19th of November, it will apply to all applications or all hearings from the first sitting day of next year, which is the 27th of January 2026. The essentials. So, as Todd mentioned, we found that with a number of these applications, they were being filed and dates were being secured, but material wasn't assembled let alone served until a couple of days before the hearing. So what we've tried to do here is to build some time in at the front end, and then so that typically a review date won't be allocated until there's been 5 clear days between service and the review date. There's an exception for cases that are genuinely urgent. So we're going to get those, aren't we? And the court will accommodate that. There's a process under the practice direction to apply for an urgent hearing, not merely a review, but a substantive hearing in an urgent case. The practice direction also builds in some notifications. Once an application is filed, the respondent, whoever that may be, will be notified by the registry by email so they know it's coming. And the practice direction requires service, hopefully on the same day as filing, but as soon thereafter as possible. So you can see what we are trying to do, which is to build some time for the respondent to consider the material, consider its position, and enter into a dialogue with the applicant in appropriate cases with a view to resolving as many of these applications as possible. If they are resolved or nearly resolved when they get to the review hearing, a judge then at that point, even though the design is for short hearings devoted to reviews, if it's appropriate, bail will be granted at that stage. The flip side of the coin is if it's apparent the application's misconceived for whatever reason. To give you an example, if an application is brought in our court, but bail for those charges was granted in the magistrate's court already, then the application can be dismissed at that stage. Review hearings will typically occur in afternoons from about 2:30 onwards, because mornings will be reserved for substantive hearings. And remember what I said about dangerous prisoner applications? They really occupy the first day of every sitting week and half of the next day. So bail applications will be, you can expect, being heard on Tuesdays through to Fridays. Review hearings can occur at any time, but typically in the afternoon, because the mornings will be reserved for substantive hearings. So if bail's granted, the orders can be processed. The parties can learn if there are any problems, for example, the wording of charges, accommodation, those sorts of things. So the idea is to give everyone enough time to ensure that the order works and the person can be released that day. So morning hearings. If bail is granted after 2 p.m. on any day for whatever reason, then the judge may defer release until the following morning. There are many examples, well, I shouldn't say many, but a few examples where bail has been granted and something's happened. There's been some issue with the draft order and the prisoner has not been released until very late that day, which is very undesirable for lots of reasons. So the practice direction contemplates that in some cases there may be deferred release. It's not mandatory, but it's something a judge will think about. The practice direction otherwise sets out what should be covered in your material. The applicant's material should be as complete as it can be at the point of filing and be accompanied by a short outline of argument. The response material also needs to be accompanied by an outline of argument, no more than 6 pages in either case. Now, an applicant going first won't be privy to the response material, so it may be at the review hearing there's a need to put in a short outline, supplementary outline by an applicant of a page or so. But we need to keep flexible. We need to move as quickly as we can, but also as efficiently as we can. So that is the general scheme of the practice direction. So are there any questions?
At the review hearings, is the expectation that the author of the outline for the applicant will appear, or the solicitor, or and how will they appear?
Yeah, I would think if council's been briefed, the solicitor could appear. Just a competent practitioner who is across the essentials that can answer some, I think, fairly fundamental questions, which I'm sure you'll all be able to answer at that stage, 5 days after service. What's the risk here? Is it flight? Is it reoffending? How are the conditions that you propose going to address that risk? They're the sort of questions that will be asked of you at the review stage. So I don't see it as essential that council be there. It would be good, but not essential. The other thing is that a number of those hearings will occur remotely. You only need to ask, and appearances can be via video link or telephone. I have to say I prefer video link because I have a lot of trouble hearing people on the telephone. But again, the idea is for 10-minute hearings, no longer, so a judge can touch that case and get the parties together and talking. Hopefully the talkings happen before, but give the case some direction before it's set down as a substantive hearing.
Are you comfortable with the Crown appearing by video link?
Yes.
So that the entire hearing could be done by video link?
It could be, yes. Patrick.
Judge, assuming that the matters identified as ready to proceed at the review, how long is it anticipated before the hearing proper will take place?
Well, that all depends. So some thought was given to that and saying, oh, well, the hearing will be in another 5 days or something like that. But it will depend upon the state of the list, so finding time. It will depend upon the estimate of time settled upon by the judge with the assistance of the parties. So through the process of refining, we hope to get a much more reliable time estimate. And we hope to get a fairly reliable position as to whether the case is actually proceeding, whether it's going to need a substantive hearing. Bear in mind, we have a lot of self-represented applications, and so the review hearing will be very useful to get to the bottom of those. But in terms of when the substantive hearing will be, that will very much depend upon what time remains in the list and when the parties are ready to go.
And whilst I don't actually have the actual stat, between an application being lodged and a hearing is about 4 weeks currently. If you lodged an application today, you wouldn't find a slot to be heard for probably 4 weeks.
Yeah, so there's a similar procedure in New South Wales, although nowhere near as good as us, of course. But there is a long period between filing and actual hearings. But there is a type of review system in that state as well. But it will very much depend upon the particular case, the availability of judge time and the actual issue to be determined. Any other questions? Yes.
Will there be a limitation hearing time at the hearing? Is it a 2-hour slot or a...
No, for the substantive hearing, no, but you'll have to move quickly. Yeah, that's the expectation anyway.
So you're not limited to 2 hours?
I'd be astonished if an application took 2 hours. It would be a rare case, but it could happen. Yes, Laura.
I'm just wondering about the interaction between the potential for urgency to be considered in listing the review.
Yeah.
How that interacts with the requirement to put material on. And I'm thinking of cases which come up every now and then where there is real urgency. There's an example, someone in Chambers was representing a woman who was jailed. She was a breastfeeding mother that hadn't been given any consideration by the magistrate who sentenced her.
Yes.
That is not a case where waiting for any number of days really is acceptable. Bail needed to be considered really overnight. Can there be within the practice direction some waiver of the requirement that there be material filed? I feel that there is some flexibility here, but it's within it, but it still says not later than 2 business days.
I think that'd be in the category of do the best you can. That sort of urgency would be recognised readily. The bail list manager is required to confer with the bail list judge. And the idea is in a genuine case, a hearing will be facilitated. That may be, look, this is so urgent, we haven't put an outline together, but this is it, and we've spoken to the Crown. Here's an affidavit on information and belief. So yes, there'll still be applications like that. We're not standing in the way of that, and we recognise that they will come.
Probably just following on from Laura's question, the applications which are often brought by the police prosecution for, as I'm
Yes.
But that can result in a stay of grant of bail. I did in one recently, a young Aboriginal boy, Dulmajin, who allegedly committed a domestic violence offence, which books in 19C, I think it is.
Yeah.
That is the magistrate's decision to grant bail. I suppose that would be another set of circumstances where the court would consider the matter as a matter of
Yeah, absolutely. It's not meant to be cookie cutter, but it is meant to introduce a regime of case management for the usual run of cases. We don't have that many revocation applications, really. They're not that common. But we would deal with each case as it comes. But for the usual run of cases, that needs to comply with the practice direction. And the mandatory requirement, really the central part of this, is that it goes before a judge on review at a fairly early stage to give it some direction. But hopefully the parties, the hope, indeed the expectation, is that by building in more time up front, the sort of cases that are resolving we're seeing late, where time's already been allocated out of the list for that case, the ones that are falling over, the ones that should always have been resolved, if we gave the parties a bit more time. So that's what we're doing.
And I think following on from that, it's a cultural change. If you're bringing an application, get your material ready before you do the application. Where at the moment, an application is made to try to save some time later on for a hearing, or in fact, if we can resolve all those matters where we're opposing them and those that actually get granted by the court and us getting closer there. And if we prevent the adjournments happening, then we'll have plenty more time, and I think it'll actually bring back the time that people will be required to await the final determination.
So the application is often made on instruction that might be taken over time, and then further material is able to be.
Accepting that, Laura, but that doesn't put anybody in a good position to actually consider the merits of it. And when we look at the statistics of it, in all honesty, most of these people are self-represented because they don't get legal aid that we have to deal with. And if you want us to make good decisions, we have to be put in a position to do that. And we're not making good decisions if we're working at 11 o'clock, 12 o'clock the night before an application because material's been sent to us, or we're spending time chasing police as to whether an address is suitable, or whether in fact the people who are putting up the security are in fact somehow nefarious. So there's a number of steps we need to talk through. And I think some of those matters you identify, there's a bell curve here, right? And there are going to be matters at the extreme ends, and we can deal with the extreme end ones if we can get the matters in the middle of that bell curve through this system, and we've got better control of them. That gives us more flexibility for those matters.
Andrew.
In respect,
Can everyone hear? Can we get a microphone? Yeah.
can I just ask,
Sure.
and in particular in respect to what within the DPPs and circumstances of urgency, real urgency, I mean, just not because someone thinks it's urgency, have you got to develop a protocol as to what type of matters are deserving of such urgency?
Yeah, that's hard to determine, right? Because every matter is going to be on its own. As you know us, we work as hard as we can to resolve and deal with things as they arise. And so we expand like a gas into the space that we're given. And if there are matters of urgency, my people will work under the pressure that they are in to respond to that. And the only times that we don't respond are when we're not in a position to obtain material from police or confirm other materials that have been given to us. The real issue is what's urgency, right?
And that was
Yeah.
the reason I frame it in that way, is because urgency can become a very subjective feature. If there is a protocol which is in place which says these are cases which may exhibit such matters of urgency that we may consider, and having that as a means and a framework, a lens through which practitioners consider engaging resources in such matter.
Sorry.
I was going to say that I think the pilot would be a good way to work that out. That if people keep applying and saying this is urgent, and then we have a discussion around that, and at the end of the pilot we say, well, here's the types of matters that were urgent and here's the ones that weren't. There are specific matters where issues around family, around youth, around support, all of those things may make something more urgent than something else. Spending time on remand when you haven't been to jail before won't necessarily of itself suggest that it's urgent.
So under the practice direction, I know you've all read the print off it, but there's a hint there. It actually talks about examples where there's vulnerability on the part of the applicant, such as advanced or young age, serious ill health, etc. But it's told, says, as the pilot runs, we hope to fine tune this. But the procedure for urgent cases is to contact the bail list manager, set out the basis as to why it's genuinely urgent. But also one of the other things is to indicate, if you know, the respondent's attitude to the application being heard urgently. So it contemplates some communication between the applicant and the respondent, whether that be Roberta's office or Todd's, even at that early stage. But we're hoping that this will work clearly and that there'll be more time to accommodate those sorts of applications as well. So I'm sure we'll all work together to make sure it works, and it won't work if we're not cooperating. And I'm sure that's going to happen.
And if I could just add on the urgency question, it's about equity and equal access. And so you bringing something on urgently pushes somebody else off the list. Well, that's obviously one of the contemplations for us as well and for the court.
I think there's another question. Yes. I might get a microphone. Just hold on a second. I'll just get a microphone to you. Can we get it? Thank you, Katarina. If you go.
I just noticed that the practice direction mandates that the applicant's outline's also done when the application is filed.
Yeah.
Obviously, we won't have the benefit of the respondent's material.
Yeah.
Does the bench have any guidance for what that first outline should really be addressing in those circumstances?
Yeah, why bail should be granted if it's an application for bail, what the relevant risk is and what the conditions are to reduce the risk to an acceptable level. If you're in a show cause, how you've shown cause. But as I mentioned earlier, that's done in a bit of a vacuum because you don't have the respondent's material. It may be necessary to put in a short supplementary outline. But that's precisely the sort of thing that will get sorted out at the review.
Thank
you. And we would hope that if the parties are moving closer to a resolution in that 5-day period, that we might start seeing a supplementary outline go in at that point and say, look, the outline covers all of these risks, but really it's about this risk. That's the concern of the respondent, and this is what we're doing to address that. And that suddenly refines the application. Yeah, yes.
Is there any provision to cross-examine the author of the objection part of it?
I wouldn't think so. No. The author of the objection to bail affidavit won't be a deponent. Anything else? No. Well, if there isn't, from our other panel members, no. Could I just, yeah, sorry, Joseph.
Thankful to talk about
Just
stats.
Just hold on, sorry.
Because I've been looking at them.
Sorry, Joseph, can we just go back? Yep.
We've got it. I think we'll pretty quickly know, in terms of Todd's statistics, in 6 months, whether or not the people in the bell curve, majority of people have been benefited from this, that is applicants, because that figure of the applications that are opposed final hearing should drastically decrease. So
Yeah.
Quick way, that'll be, in 6 months we'll know that.
Yes, I hope so.
Yeah. And if they haven't, well, something else is going on to investigate that.
Yeah, well, we won't be sitting idly by either while the 6 months is happening. We'll adjust as necessary, but this is a very good place to start. I think you'd all agree.
So I think they're helpful. And also I think there are recognised categories of risk. If you can establish with proper evidence that someone is a suicide risk, and that does happen, genuine suicide risk, and that often seems to be combined with youth and no previous experience of prison, or as His Honour said, vulnerability in another sense, someone who has a mental illness, who's the first time in custody, is often genuinely vulnerable. So those categories, if they can be, I would have thought, supported by proper evidence, will be acknowledged by the Crown.
My experience has been bail refused in the morning and then granted by Supreme Court Justice, I think at 1:15 that afternoon, on perhaps even by chambers. So I wasn't saying it wasn't slow. It's not there.
Yeah, no, I'm not disagreeing with you at all. I think it's a very valid point. And I think we all know that it's just a question of proving that a person is in that vulnerable category.
And
That's what's difficult sometimes.
That's half a dozen matters in reality in a year, if that. And I'm looking forward to a reduction in the number of defence adjournments. I'm looking forward to a reduction in the number of defence adjournments over the next 6 months, because the applications are in a good position and we can go ahead. But again, you know, the matters like the suicide risk, those sort of things, we're always available to address those things. The court's always available to do them. And I think we do bail pretty well in this state, to be honest, in getting people before the court.
Yeah, look, I can only endorse that. I don't think those particular applications will pose any problem at all. I think they'll be met in the same way they're currently met. So, could I ask whether anyone else has a question? Apart from Mr. Hall? Not from our panel? All right. Rebecca.
Yeah, I just wanted to ask, is it anticipated
We'll just get, sorry.
Thank you. At the review hearing, the review judge would give an opinion on things like whether an applicant had shown cause, or there are a small number of Commonwealth matters where bail can't be granted unless there's exceptional circumstances, or is that something that would be dealt with at the...
That's really a matter for the substantive hearing, but some judges have been known to express preliminary opinions, and that might happen at review hearings. But yeah, really that's a matter for the substantive hearing. Bear in mind also, the bail list judge, who will be me for 6 months, will sit initially on these applications for a couple of weeks. Then it will be a different judge sitting each time, and the review judge may not necessarily be the judge hearing the substantive hearing, because that'll depend on the list. So, you know, it might be a review on Tuesday afternoon and there's time available on the list Friday afternoon or Friday morning to hear it. Well, then it will be the same judge, but I don't expect that will usually be the case. So one judge isn't really going to bind another, or can't bind another judge as to whether or not someone's shown cause.
And Judge, is it anticipated that, you mentioned before, if there was a technical issue, the matter bail could be refused, is it anticipated that at the review hearings bails could be refused?
Yeah. So, yeah, thank you for that question, because I've not made that plain. What's built into the practice direction is the maximum flexibility. So if there can be a final disposition at the review stage, that will happen. And that may be the Crown appearing and saying, we've looked at this and we're not opposing bail, provided these conditions are imposed, and then telling the judge about it. And if that's an appropriate case to grant bail, it'll be granted. But that may be one of those cases where that's happening at 3 o'clock and the judge grants bail, but orders that release not occur until the following morning. Because there's a whole process that goes on after a judge grants bail. I mentioned notifications before. One of the notifications is to the respondent when a bail application is filed. So that's a heads up that something's coming in. There are other notifications at the end of the process to the police. So this is from the registry will notify the police at a central point that about the bail outcome, whether it's been refused, varied, revoked, and we're granted a copy of the order, a scanned copy of the order will be provided to the police, which as I understand it, then will be uploaded to Q Prime and will get to officers in the field. So that's another measure that's taken in the practice direction to communicate effectively and widely to the right people the conditions that have been imposed on grants of bail. Nothing else? Well, thank you very much for attending. As I said earlier, I'm really grateful for the response both in person and online, and we look forward to working with all of you to get the best out of this pilot. Could I thank each of our panel members, Roberta, Todd, Joseph, Angus and Patrick. And can also thank Robin Kinney, the head of Court Media. Where are you, Robin? Over there. Bridie Allardyce, my associate, Katerina Tomasello, my secretary, as well as the Court AV staff, and also security. You may have met them on the way in, who have put all of this together and done so flawlessly. Thank you.